This is English shorthand dictation number 370 and the dictation speed is 120 words per minute. Ready? Start. The present appeals have been filed against the orders passed by the High Court, while which the order passed by the trial court was set aside by the learned single judge. The brief facts of the case are that a civil suit was filed by Sheila, widow of Narendra, for declaration, partition, and separate possession of the family property. In the aforesaid suit, counterclaim was filed by the defendants. The preliminary decree was passed by the trial court on 27/02/2012, determining the shares of the plaintiff and defendant numbers 1 to 8. The defendants were restrained from alienating the suit property till partition takes place by metes and bounds. The preliminary decree passed by the trial court was not challenged by the plaintiff and defendant numbers 1 to 8. Defendant number 9 was held to be having no right, title, or claim in the suit property. The defendants were directed to demolish the construction raised in violation of the municipal laws. It is the aforesaid preliminary decree which was challenged only by the defendant number 9, namely the present appellant before the High Court. The appeal was dismissed while modifying the operative part of the order of the trial court only to the extent that the defendant numbers 2 and 9 were directed to demolish the construction on the suit plot forthwith. The issue was sought to be raised only by the appellant, who is not a member of the family as such, but is claiming his rights through some of the co sharers. The plea of the appellant was that the respondent number 2 had transferred his share to him with the partition of the property amongst the plaintiff and defendant numbers 1 to 8. His rights are adversely affected as he has spent huge amount in raising construction on the plot. After hearing the learned counsel for the parties, in our view, the order passed by the trial court passing the preliminary decree in a partition suit as upheld by the High Court does not deserve interference by this court, as admittedly there is no challenge to the same by any of the co sharers of the property in dispute with reference to their respective shares. The final decree is yet to be passed. At that stage, the property will be divided by metes and bounds. The preliminary decree is being contested only by the appellant, who claimed that defendant number 2 had transferred his share to him. In some part of the property, two residential houses are located which are stated to be in occupation of respondent number 2 and respondent number 3, whereas on the other part, a commercial complex has been constructed in which the appellant is claiming interest. We have no doubt that in the process of passing final decree for partition of the property by mates and bounds, the court below will consider all aspects in terms of settled principles of law for that purpose. In case any property in possession of any of the co sharers comes to his share, it can very well be protected. In our view, demolition of the already constructed buildings may not be in the interest of any of the parties, as the same can be considered at the time of passing of final decree with reference to the construction authorized by the local authority. We are not expressing any opinion on the illegal construction. For the aforesaid reasons, The impugned orders of the High Court are modified to the extent mentioned above. The appeals are accordingly disposed of. The trial court will proceed further for passing the final decree. There shall be no alter as to costs. As the matter is quite old, the trial court is directed to expedite the disposal of the case. We may clarify that we have not expressed any opinion on the merits of the controversy. We have heard the learned counsel appearing for the parties. The appellant has been convicted for the offense punishable under Section 302 of the Indian Penal Code. The conviction of the appellant by the Sessions Court has been confirmed in appeal by the impugned judgment of the High Court. We must refer to the case of the prosecution in brief. PW2, the brother of the deceased, is the first informant. PW3 is from the same village in which the appellant and the deceased were residing. According to the case made out in the complaint, PW1 was at the grocery shop of PW2 with one Suresh. We may note here that date of the incident is 12th November 1997. According to the prosecution case, the deceased started proceeding towards his field at about 3 p.m. He was followed by the accused with a bamboo stick in his hand. The accused came back near the shop around 6 p.m. with a stick in his hand. According to the prosecution, the appellant confessed before PW2, PW3, and one Suresh that he had assaulted the deceased with a stick. The motive pleaded by the prosecution is that on 28th October 1997, the appellant Ashok and Bhima consumed liquor and a quarrel started amongst them. The Sarpanch lodged a complaint. In the said proceedings, the deceased took side of Ashok. With the assistance of the learned counsel appearing for the parties, we have perused the notes of evidence and other documents on record. The prosecution has relied upon extrajudicial confession of the accused allegedly made before PW2 and PW3, recovery of X at the instance of the accused, coupled with evidence of PW5, who claimed that the same X was taken away by the appellant from her house, and blood stains found on the clothes on the person of the appellant.